usually takes a while to buffer. So can you give me a green light when it works? Is it streaming? Okay. Hello and welcome to the Modern Divorce Navigator live office hours. I am your host, Billy Tarasio, Arizona family law attorney, not your lawyer. And this is a feature of the Modern Divorce Navigator where our members can come ask questions every week. Remember that this is not a substitute for legal advice and nothing you tell me is confidential, nor do we have an attorney client relationship, but we are here to help. Mary Alice, hi, how are you?
Hey, Billy. I'm good. I just got out of court. Um, Minors Counsel had great things to say. Um, with the progression with seeing Emily and with Alina, my oldest, being back in the picture. And so ultimately, the judge was getting very frustrated. My ex kept going around in circles, bringing up the accusations and all that stuff all over again. So, what ended up happening was the judge said, I don't believe anything that either one of you are saying that's coming out of the children's mouths. And so it really was kind of like really discouraging because, I feel like I keep getting put in the same bucket and category as him. And, the judge had to tell him a couple times to calm down. I didn't like that he was able to show evidence that he hadn't submitted. So there was one piece of like attendance that he wanted to contest what the minors counsel had said in the last hearing. So he wanted to say, hey, look, like they've been, their attendance at school is good. And so the judge passed it, had the bailiff pass it to me. I looked at it and then the judge looked at it. It was only 1 month's worth of attendance. It wasn't the entire year. So I don't think that had any weight on the situation. But ultimately, my request was for equal time.
Mm-hmm.
And so I didn't get that. He gave me every other weekend. So, because it was weird, like the initial schedule was I pick up Adriana on Friday at 6 p.m., drop her off at 8 p.m., and then pick her up Saturday morning at 10 p.m. for my weekend. So he cut that out and just did 6 p.m. pickup Friday, 6 p.m. return on Sunday. So that was good. And then he gave me a Wednesday overnight. And I still get my Tuesdays, but I still return her at 7:30 on Tuesday and then get my overnight on Wednesday and then return her on Thursday. So, and then minors counsel asked if I can get 1 week out of the summer. The judge agreed and said, okay, well, you guys agree on what that week is, and if he doesn't agree to that week, then minors counsel will file an RFO. And so I asked, and the minors counsel asked if we can have another status hearing in August. The judge declined it and said, no, we're not having another status hearing. So now I'm left with these kind of wonky visitation schedule and no status hearing. So I was disappointed that there's no like next steps so that I can get more time with my daughters. So I'm not quite sure how to take today and what I can do next.
So was this a final order?
No.
Okay. I mean, the biggest question that I have for the judge is what's it going to take for you to get equal time with your kids? What's it going to take? Like, articulate it. Let me know.
Yeah.
Because how are you supposed to? It's like you're chasing, a moving ball. Um, what do you do because there's nothing set? Okay, so it's not the final hearing. How does the final hearing get set?
Well, I requested a trial for the home and the business. I don't know how, I mean, do I request a trial for the child custody as well? So I'm just not sure like how this works out. And you're right, it's like I'm being breadcrumbed and there's no need. It's been 4 years and, I just don't understand it.
Okay, so two options then. You either request a final trial or you request, you file a motion for another status hearing. I would maybe do another status hearing first because I don't like where we're at, so I don't want where we're at to become a final order.
Mm-hmm. Mm-hmm.
So I might request one more status hearing and just file a motion. I know he said no today, but I would just do it again. I would just keep asking.
Okay. So filing a motion is, that's not a request for order, right? It's a different type of document?
A request for order is requesting that the judge order something specific.
Okay.
Can you do, I don't think you could do a request for an order for more parenting time without having a hearing, right?
Right.
So then you're going to have to request a hearing or request a status conference. And
Okay.
you can ask minors counsel, you know, what's the type of hearing I need to request here? Because it sounds like she's on your side. She
Mm-hmm.
thinks she should be getting more time.
Yeah. She is.
Well, then between the two of you, I think I think the fair question to the judge from you and from minors counsel is, what's it going to take? What are we waiting on?
Yeah. Right.
And you know, when the judge is unable to articulate anything, then maybe you get your order.
Okay. So I file a motion for a status hearing. Should I do that right away or should I wait?
I think you should wait.
Okay.
I think you want to be able to say, you know, at least after a month or so,
Mm-hmm.
here's what has happened since. Like, there's what are we waiting for?
Yeah. Yeah. That's what I'm just like, I don't understand. Like, we can't keep going off of his old allegations. Like, those are not relevant anymore. And there's no 3044 that's been rebutted. I just don't get it. I don't
Right,
understand what I'm going after and how to get, I mean, I know what I'm going after, but how do I get there?
right. And so that's the argument. And so first you do it in writing, and then you do it in person, and you just keep making the argument. You know, judge, you've already, like, all of these things that kept me from my children have been resolved, and you know it.
Yeah.
So what are we doing?
Yeah. Okay. Okay. I like that because you're right. It does worry me that these are going to turn into final orders and I'm just not where I want to be yet with them. So, okay, file motion for status hearing and wait
Yep.
about a month, because it takes what, like 30, 60 days to get that date?
I mean, I don't know how long it takes for them to set these things.
Mm-hmm.
You have hearings much, much, much more often than we do. But I would put all of the arguments in the motion for the hearing.
Okay.
All of them. I would put all of the arguments in.
Okay, in the motion. Okay, got it. Okay, that's all I have right now, Billy, but I'll hang on just in case something else comes up.
Hey, sorry today didn't go as well as we wanted it to.
I mean, but do you think like at least I got more time, right? I'm really trying to see the silver lining on this, and it's just it gets. I mean, I got more time, and I think that there's a lot that I can do without a court order, like as far as, re-engaging with Emily. Like I'm taking her to get her nails done today. I'm going to her dinner graduation tomorrow. She's
Do you
getting
have
ready.
every other weekend with her too?
Well, the judge said it's up to her discretion still.
It's interesting that a 13-year-old has that much discretion in California.
Yeah, and the other part is that he's not, which we didn't even get to touch on today, was the legal decision making. Like I looked, he's taken her to the emergency room, never let me know. There's something wrong with her ankle because when I took her dress shopping, she's hobbling her way through the mall. She needs to get an MRI. Like he's not, and then he's signing her up for another soccer season with her injury because she wants to play soccer. Well, that's why a 13-year-old shouldn't be allowed to make these decisions because she needs to get her injury looked at and not continue making it worse by starting up another season of sports.
Right. But you know, you're not wrong that sometimes the fastest way to the end goal is not through the court. It
Yeah.
could be that you do what you need to do to build the relationship with Emily, and Dad does what he always does, and there comes a day where she says, I'm done, Dad.
I have a really strong feeling that that's the direction that it needs to go, honestly, because the court is doing I don't know what, and I've been getting a lot more results by doing this, navigating it with her on my own as best as I could. I think the part right now that makes it a little bit delayed is that she's no longer in school sports, so
Mm-hmm.
I get less access to her. So the
Mm-hmm.
only access I'll get is like on the weekends during soccer.
Mm-hmm.
But that's been working. That's how I got to where I'm at right now, and having spending time with her was to going to these games, talking to her,
Yeah.
you know.
Yeah. You
So
just
I
keep
think,
showing up.
yeah, thanks,
Yeah.
Billy. Yeah.
Thanks, Mary Alice. All right, Nicole, how can I help today? We cannot hear you, Nicole. Marjan, do you know if an email went out today to all the members reminding them of the office hours? That usually happens every time we have office hours, and I'm wondering if that's maybe not why we don't have people. It did go out? Oh, okay. Hello, Nicole. Oh, I cannot hear you. Okay, sounds good. All right, Alicia, if you can hear me, go ahead and unmute.
Hello.
Hi.
I tried joining from the link that was posted today and it didn't work.
In
So
Facebook, in the Facebook group?
yeah, yeah, Facebook group, just so
It
you know.
does. It is bizarre that there's not more people here. So I will post the invite link as
I ended
well.
up I ended up going to last week's and clicking on that link and it worked.
Okay, good. Well, thank you for letting me know. All right. So how are things? How can I help today?
Well, we got our ruling, so things are okay, but not great. We will be filing a motion for reconsideration, but before that even happens, we have to. So she tasked the mother's attorney with, preparing the orders. And so we just got a copy yesterday of the orders, and they are not even close to what the ruling was. It's like really bad. He basically took some of it and kind of fit it into her proposed parenting plan. We're talking like she had in her proposed parenting plan, because pickups have always been from each parent's home, she put in a midpoint transfer location of the police department. Um, the the court pretty much adopted quite a bit of the evaluator's recommendations from the parenting evaluation, but not all of them. And so, like, one of the provisions was that their daughter, who's 16, has the option to elect to miss one visit a month. And then she added her own provision in there that the court did not order, that when their son reaches the age of 14, that he can do the same thing. I mean, they just took so many liberties, and like, I mean, it doesn't even closely resemble what the
Okay. Can I stop you for a minute? Because okay,
yeah.
so the last I remember, you were going to court to hear the judge's ruling orally. And we talked
Yes.
about how you were going to make sure that you got a ruling on every outstanding issue. Did that happen?
For the most part, yes. Yes, every that happened. So what she did was the outstanding issues were um, limitations. So this is one of the things that we'll be doing the motion for reconsideration for, because she did put a limitation on my husband for a history of acts of domestic violence. That is not supported by the law. So that will be a motion for reconsideration. But then the evaluator had recommended all of these therapies and conditions to go along with it, including domestic violence treatment, DV dads. She did not order any of the therapies or treatments at all. She only adopted the limitation. And then she also put a limitation on my husband for a history of alcohol, which affected his ability to parent, which is in the past. And so she put that limitation, but did not order any of the SoberLink testing or like UA request by the mother, because he's been sober for over 5 years and there's been no recent problems with alcohol. So she like put the limitations there, but didn't order but other than that, she adopted the evaluator's recommendations as far as the residential schedule goes. And they completely changed times,
Okay, so
holidays.
okay, so the judge gave you her ruling, which adopted a lot of the evaluator stuff, but not all of it. And then you received a written ruling that is inconsistent with what you heard. Is that what you're telling me?
No, what I'm telling you is that she asked the attorney for the mother to draft the orders.
Okay,
And
and
so
they
this
are
is
inconsistent with what the judge said on the record.
completely
Okay.
inconsistent.
Okay, so you need to get the transcript from what the
Mhm.
judge said.
Yeah,
Okay?
and yes, I have ordered that,
And
and I'm
then
doing the
and then
track changes.
and then you file an objection.
Okay, so I want to file an objection.
You want to
Okay,
file an
that's
objection.
okay.
And then
Yeah, I did already respond because it was he emailed the orders to me and the court, and he responded right away saying that, he was at work yesterday and needed time to review them, that at first glance he saw several errors and omissions and, additions.
this is
And
what
so,
your husband said?
yeah, in email. And so the court asked the track changes Word document to be
Okay.
forwarded when he's done with it. So, but I
Okay.
do think that with the amount of changes and things, that there should be a formal objection or declaration filed.
Okay, so you're already in the process then. Okay, so you've got two different things going on now. Okay, you have the orders that the judge made and making sure that what is in writing matches up. And then
Mhm.
secondarily, you have did what the judge actually ordered, do you want to make any appeals or objections or motions to reconsider to that? So two different issues, right?
Right. Yeah, I've been just focusing on making sure that the orders reflect the judge's ruling before they're
Exactly.
signed, because then
Yes.
once they're filed, we have 10 days to file the motion for reconsideration. So while that's kind of like in the back of our head, it's not, the first is we have to get the orders signed and then we can
Okay.
motion to reconsider.
Okay.
But
Okay.
yeah, I mean, she expanded his parenting time quite a bit in the summer. It's basically 50-50 in the summer. He'll have every Thursday, Friday, and then every other weekend will be Thursday through Monday
Okay.
for the summer. And they completely left that out of their proposed orders.
Okay.
I
Well,
mean,
that's
it's
that's
just
okay, right? So this is not a problem that you can't solve.
right. I know. It's just infuriating that, and this guy is actually the attorney serves as a pro tem commissioner in the family court, and I just feel like it's not an oversight. He purposely just basically tried to fit a few of the evaluator's recommendations into her proposed parenting plan, and to me it just feels like
Well,
unethical.
did the judge adopt those? Like it really
No.
what the evaluator said is irrelevant. What mom wants is irrelevant. Only the judge's words in their order
Right.
matter. That's it.
What she did was she pulled out the evaluator's recommendations and we went through them number by number. And she said, the court is adopting this. The court is not adopting this. The court is. And so that's how I know exactly what it should say, because we pulled it out and went along line by line. So the court did not adopt any of the treatment recommendations for the father, only for the mother. And it's funny because it says the mother should maintain behavioral health care, including medication management. And then there's a bunch of other things where her clinicians are instructed to do certain things and file things with the court and collateral to the dad, and they left all of that off, just saying that the mother should, and so they just completely altered the recommendations and wrote a parenting plan that she wanted. It's ridiculous to me.
Yeah.
So yeah, so I've gone through and I've done like the track. We've gone through and done the track changes, changed everything with comments to what it should be according to the oral ruling. But I did think, and I've been using Chat GPT to help a lot, and it recommended filing a declaration also, like formally, to object. And do you think that's reasonable?
I mean, that's what I would do if someone submitted a proposed decree to the court, which is what this is, and it was
Mhm.
not in line with what the court said, I would file an objection.
Okay.
And you need to wait or have enough time to have the transcript because you're going to need to cite to that transcript. The judge isn't going to
Mhm.
remember everything they said, you know.
Yeah. Yeah, we ordered it the next morning. But I also put in an order on the 18th for the trial transcripts and still are waiting on those.
Right. So this may
So,
take a while, but
okay.
the updated parenting plan is in effect. So he has more parenting time.
Oh, it is. Okay. I wasn't sure if it was in effect or if it wasn't until it was signed.
It is when the judge orders it orally.
Okay. All right. Good.
Unless there's a
Okay.
different rule where you are, but once a judge
Okay.
says it, it's yeah.
Yeah. Okay, well then I will have more questions to ask about the motion for reconsideration and the DV limitation, but I'll hang out and let other people go, and if there's time, we'll get to them.
Okay, sounds good.
Okay, thanks.
Nicole, how can I help today? No, I cannot hear you. If you want to type into the chat, we can do it that way. I'll read it. I'll just give you a minute to do that now. All right, we're still waiting. This is from Nicole. We're still waiting on orders, but the judge's minute entry this morning states that my request to deem admissions admitted is denied without prejudice. Did they tell you why? For the reasons stated on the record. But my question is, we discussed it and the responses were admitted to evidence. Oh, Nicole, I don't think this is working via chat. Why would they be denied but still allowed into evidence? Okay, so you gave the other side a request for admissions. They did not get you responses or complete responses in 40 days. And you had a hearing on this and you argued about it, and the judge said they weren't going to deem them admitted, so then you filed a motion. Is that correct? Do I have that timeline correct?
Okay, now let's try this. Let me, can you hear me now?
Yes.
Is it echoing?
Yes.
Yes, hold on. We're gonna try from my phone.
Okay, so can I?
Oh, go ahead.
Awesome, perfect.
Okay, good. So, I submitted my request for admissions. He responded within the 40 days, but it was after the deadline of disclosures.
Okay, but it was within the 40 days.
Correct. So he responded May 7th. Our hearing was a week ago today. We just had the minute entry that says that the motion to deem admitted was denied.
Sure. I don't think the court can't change the rules. The rules say you have 40 days. And if you don't respond in 40 days, then they're deemed admitted. The court can't change the rule and say, or this other discovery deadline.
Okay, perfect. Okay, so I don't need to worry about it because the judge had looked at the requests and said, this doesn't look good for the petitioner, but it was admitted into evidence. So don't panic that my motion was denied at this point. We just wait
No.
for a ruling.
I would not panic.
Okay, we just keep waiting. All right. Thank
That's it?
you. Yeah, that was
That's
it. That was it.
Okay.
Thank
All right,
you.
thanks, Nicole.
Thanks.
All right, Tani, how can I help you today?
Hi, Billy.
Hi.
How are you?
Doing great. How are you?
Good. Okay. So I have a couple questions. I'm still getting ready for my evidentiary hearing for my petition to enforce. Quick question. Do I have the ability to request interest on the 3 judgments that were ordered back in 2015?
Yeah, you don't even have to request interest. There's statutory interest that's automatically applied.
Okay, and where would I see that that has been applied? Because I don't see it anywhere.
What do you mean?
Like, they gave me a printout of something from, I believe, like the child support division, a printout of like what was owed, that $300 or $3,000 arrears. So I don't see like any proof that any interest has been applied to anything. So I was just curious, would that show up anywhere, or do I just go to the hearing requesting that interest is applied?
if it's not already applied, then yes, I would request that the interest be applied. Absolutely.
Okay, I just want to make sure that didn't make me look like aggressive or for requesting those because they are judgments.
Right.
Okay. Um, and then for the evidence and like submitting documents, it does recommend that I do it. They gave me access to that case center digital evidence.
Mhm.
So once I file it, upload everything in there, do I just have to email all those PDFs to opposing counsel's attorney and that's good?
No, I believe through Case Center, it's automatically sent to the opposing counsel.
It is. Okay, so I don't have to use like the e-file Arizona portal if I'm using the case center?
So Case Center, I believe, is for exhibits, right?
Yes.
Not filing documents. So once it's been submitted to Case Center, that goes to the clerk of the court. And
Okay.
then it makes it available to the judge so that when you're in a hearing, you can request that the evidence be admitted.
Okay, got you. And so I understand that, but do I have to file it with like the AZ
no,
e-file to
no.
make sure it goes to the ECR and stuff or no?
No, no, no.
Perfect.
Exhibits do not become part of the record until they're admitted at trial. They never
Gotcha.
get filed. Yeah.
Okay. And then last thing, I'm trying to prepare, it says that you can like cross-examine and do all of those different things at an evidentiary hearing, and obviously I'm representing myself. How, in that case, how do I redirect myself? Like if I was to ask him questions or do something like that, usually if you're represented, your attorney comes back around to, so you're able to clarify certain things or something like that. How do you do that when you're unrepresented?
So, let's say you call a witness,
Okay.
you ask them questions, the other side cross examines that witness, then you're allowed to redirect. So there's
Okay.
no redirect after cross. So if you cross examine his witnesses, you don't get to redirect.
Okay. Okay. I was just curious. I'm like, I don't really know how this plays out because the way it sounds, it's like you can have witnesses and cross-examine, and I'm like, aren't we just making a statement and presenting evidence?
Well, who are
And
your
it's more
witnesses?
judge-led than people-led? I don't know.
Usually, but it depends on who the witnesses are. So who are your witnesses?
I don't have any. I didn't think to have any. I was just gonna go in there and basically it was simple math. So I don't really know what else to say besides, it's not on me to prove what's been paid, and that would be on him, and he has no proof according to his disclosures. So isn't it kind of basic math? Is there anything else that I should really be preparing for?
Well, I'm not sure that I know all of the issues in your case to answer that question.
Okay.
So
Yeah, it's,
is this
I mean,
divorce, no children, we're just dividing
it's
property?
there is one child, and the
Okay.
3 judgments that have been placed on him were for child support arrears,
Okay.
birthing expenses, and unreimbursed medical. For
So
the
this is just a petition to enforce?
mm-hmm.
Okay. Okay. So you're going to go in and you're going to say, this is the court order and this hasn't been done. And then
Yep.
it's on him to show it's been done, just like you said.
Okay.
And so you're going to make a statement, and then he's going to have the ability to ask questions of you and your statement.
Okay.
Then he's going to get to make a statement. You're going to get to cross-examine him.
Okay.
And let's say you make a statement, he cross-examines you. You have the ability to redirect yourself after that. So that's when you can ask, Judge, I'd like to exercise redirect and address and clarify some things that came up on cross-examination.
Okay. That makes sense. Cause yeah, that's what I was wondering. Like if he says these things or does that, how do I like redirect and clarify when somebody's when my attorney isn't asking me,
Right.
right? Okay.
Yeah. So,
Um,
and it really depends on how it goes. So on traditional cross-examination, the lawyer will not let the witness answer anything except for yes or no, which is why you need your attorney to redirect you. Now, if he asks you questions and then allows you to give your elaborate answer, then there's no redirect because you've said everything you need to say.
okay. Okay. Perfect. Um, yeah, I think that was all I had. I'm just trying to prepare for that.
When is the hearing?
It's June 12th.
Exciting. Coming right up.
Yeah, it's coming up quickly. There is another issue outside of this petition to enforce, which is in regards, I know last time I'd asked you about presumptive decision authority.
Right.
Yeah, there is since father has medical in regards to the child, I'm wondering, you'd said to file a motion for clarification. Just recently, I believe the child's epilepsy medication has been increased, where the doctor did, say that we could do that.
Yeah.
But I haven't been notified. The only reason is I have access to a portal so I can see conversations. But I haven't been notified by dad that there's been an increase or that it's taken place. But I know that it has because of the portal, and I'm wondering if that is good evidence to use, because aren't they supposed to make a good faith effort to discuss medical decisions or medication increase prior to just doing it because you have presumptive authority
Yeah,
decision
definitely.
making?
Definitely. And I think it's
Okay.
super irresponsible that medication would be increased without your input or knowledge. Like, how are you supposed to know if you're even giving the right dose? Does this child live only with dad?
No, we split 50-50.
So it's really kind of dangerous to not be communicating about this type of medication.
Yes, and unfortunately, we just had a issue with that, where there was an increase and I interpreted it differently. And I don't see the dad, his wife, stepmom comes in as a placeholder typically to do exchanges, to
Yeah.
tell me about medication increases, and then he had reported me to the doctor. This is about the second or third time I've been reported for not following medical instructions. And now the doctor's kind of siding with him and won't really give me. That's why I was started to ask these questions, is when I'm past appeal, when do I have time, or when is the best time to say, okay, you gave this to dad medically, but now I feel like he's abusing, because the child went from being on no medication at all to 3 medications, 2 are maxed out, and increasing another one with the third medication without telling me. And the only reason that we kind of lost that is because I more of a, you know, or like holistic, let's try this and that, not saying I wouldn't put him on meds because he has been on meds prior, but the judge didn't see that as well enough and gave it to dad. But now I'm getting little to no respect in regards from the medical team and then from dad. And they're just kind of off doing their own thing. And I don't think that's legal.
Okay. Well, you have two issues. You have contempt for failing to follow the rules of joint legal decision making, which include
Okay.
giving you information and
Right.
including you in the decision making. And then you have a potential modification if this is a change in circumstance, and a modification would be in your son's best interest.
Okay. So I could take both. You recommend taking both routes eventually.
I don't It depends on what you want. So, and what happened previously. So this issue's already been litigated, right? Mom's view of how to handle this diagnosis versus dad's view. And the court sided with dad. And so now if you are asking the court to change its mind, you're going to have to show that dad's decisions are detrimental to the child, not just that he didn't follow the rules.
Okay. Okay. And
And
that
if
was our
you- Sorry.
that that's okay. That was our previous why we litigated, and I actually went back to court after 2015 with you guys, is because there was an element of uh emotional and verbal abuse, and I was concerned for the child because the child started showing things that were concerning that I had gone through. So we initially filed to show that the child was in harm's way, but in that I ended up losing the medical because at the time the child was not on his epilepsy medication. I followed instructions to wean off by a neurologist, but we were seeing seizures again, and dad and I were trying to come to an agreement about how to treat it. We went back to trial, but in that I ended up losing medical. They told me that my case for, abuse was not valid, and that actually I was the harmful one, trying to limit dad's relationship. And it went completely the opposite way we had intended it to go of what was really going on. So now it's been almost a year and the child's maxed out on meds, and there have been some decisions that haven't been very good, or I've been pushed out. So I'm wondering, when can I go back and say, I don't think we made the right decision here?
Well, I think you have a clear case for contempt. I don't
Okay.
know if you have a clear case for a modification, because just because he's on 3 meds and he's maxed out doesn't mean that that's not in his best interest. You have to
Right.
have evidence that this is not working.
Okay. So an issue for contempt. Okay. Got it. Well, that was all I had for today.
All right, thanks, Tani.
Thanks. Have a good day.
You too. Lisa, how can I help today?
Hi, Billy. Yeah, hi, how are you?
Hi, doing great.
Thanks. I had court today, and so my ex, the father of my child, his attorney filed for a emergency order to vacate the judgment that was entered on January 15th, and this was the hearing for it.
Okay.
Judge did not grant the emergency motion to vacate. And then today, the outcome was such that she was about to vacate the emergency order and go back to 50-50 parenting time, which was, done in 2021 of March. The GAL recommended not to do that because my child is going to a therapist currently. And so then the judge kind of backtracked and said, okay, let's give 30 days. So at this point, I'm concerned that she's going to go back to 50-50, but I'm not sure how the judge looks at that when the GAL is basically not, I guess trying to prolong the current parenting time scenario.
So, where are you at?
So currently, the dad has suspended parenting time, so no parenting time overnights.
Where are you at geographically?
Oh, I'm in Chicago, Cook
You're in
County.
Chicago. You're in Cook County. Okay. So dad's parenting time was suspended based on what?
The child did refuse to go to the dad's house. She's 13. Going to be 13 next month. She refused. She's been having panic attacks, anxiety, fear of being at his house. And she told me that she was going to run away and kill herself if she's forced to go there. So I filed an emergency order back in January stating that, and that the child was endangered in harm, threatening self-harm if she continued to go to dad's house.
Okay.
And the judge granted it,
Okay.
granted the emergency.
And so objectively, what is going on at dad's that would warrant him not having parenting time?
That's the problem, is that I don't know what's going on. I think it's coercive control. I think he is bullying her, and there's verbal abuse and emotional abuse and psychological abuse.
Okay. And has she articulated that specifically to a therapist or a GAL?
No, I don't know if I think it's so hard to verbalize that and to prove that, right? But she'll pray, and she has anxiety, stomach aches, panic attacks where she is about to faint. She'll black out. She has to lay in her bed when she's there. It's ongoing. It's been ongoing for a long time. And it's been documented with the therapist and the GAL that this is happening to her physically. She wants to throw up constantly when she's there. And the therapist has noted that she has a fear of being there and anxiety, major anxiety. The GAL has also noted that with the court, that the child has a fear of going to the father's house.
Okay.
I think, because I was verbally and emotionally abused in the marriage, I think this is what's happening to her now. But it's just so hard to know because I didn't know this was happening, and I'm an adult.
Okay.
I don't know what to do in terms of like next steps, because my daughter's attorney is now asking for the court to do a 60410B, I believe it is.
Okay. What is that?
Oh, yeah, for Illinois law, it's in the statute where if there's conflict with the parents and over custody and parenting time, that an independent psychological evaluation gets done for the parents.
Okay. Okay. So, what is your question? Are you wondering like overall strategy?
Yeah, I did speak with just something to note. I did speak with the GAL, and he said, you know, it, now that she's in the therapy, and she's older now, this could drag on for a while, and she'll be older, and so that was kind of his thing on me, his take. And so he, in court today, he did not want, he didn't think it was the best interest for the child to go and to undergo another psychiatric evaluation of this sort. But from my understanding, these evaluators typically go 50-50. So it's like a waste of money, is what he was saying. I think that he's advising the judge that we keep the current day parenting plan and then give him an extra day, and that he said that there wasn't imminent endangerment to the child. And so her father's argument is that the lawyer's argument is that there's no endangerment. And so it's just so hard because it's not physical, but it's mental and emotional. It's so hard to prove. So I guess my question is, I have two questions. So one is that, this attorney has not put in another court order because she didn't get what she wanted. She wanted this to be vacated.
Right.
So she didn't get it. So she's doing the same thing she did back in when she brought this before the court as an emergency, and the judge said, no, it's not an emergency. I'll hear it in 2-3 months later.
Right.
So she did. And then the GAL had recommended that the father see, my child after school 2 days a week when she was free. So that's all her free time. And, it's like Sundays all day. So he's seeing her, but he's adamant about getting 100% custody of her and saying that I'm alienating her, parental alienation.
I think there's a real risk here for that, honestly. I really do. Because it's just too loosey-goosey, the position. She has stomach aches. Like, I believe you. But if you don't tell dad this is the behavior that's causing this, if he has nothing, nothing to work towards, a judge is not just going to say, oh, she doesn't like her dad. He makes her sick. She doesn't have to see her. You know what I mean? I think there's a huge risk that you will be labeled an alienator. So I think if I were you, I'd be working real hard to get detailed information about why she doesn't want to be at her dad's.
Oh, like, so for instance, would the fact that, if she had a recital or a dance, an important day that she had to be somewhere, and then he just pretends he doesn't know the address and doesn't know how to get there, and then is late, purposely creating anxiety and havoc and chaos in her life because he just
When
doesn't
when
want.
he's supposed to take her there, he's supposed to take her to a recital, but then he
Mhm.
won't.
Right, right.
Okay.
So that's, one specific incident that I know of.
Okay.
And he has not supported her in her extracurricular, so he just keeps her at school, on his 50 parenting time. He has a pattern of just not taking her anywhere, and then she's upset because she wants to go. She needs to go. She loves dancing. It's like it's her home away from home.
Yeah.
And
So
so
she wants to do dance and dad won't let her do dance.
right. And I have to
Okay.
go to court every few months to petition to the court to do this because we have shared custody and everything is shared.
Is there an order that he take her to dance?
Yes, then there was an order. Yes. So then that,
Okay.
yeah.
So I think that you're going to be much better off not focusing on her symptoms,
Okay. Mhm.
but instead focusing on this is why daughter is experiencing symptoms. And how do we know this isn't like from a judge's perspective? Okay, dad doesn't let her do dance, so she has anxiety? Like I don't see it. I don't see that link. I can see her being angry, frustrated, not wanting to be with dad, but I don't know how dad not letting her do dance can create anxiety.
Um, I suppose the other argument that I'm trying to make before the court is his violations of the mutual no contact order since it was placed last May 31st. So it's been a
Okay,
year.
we have to be
Oh, sorry.
really careful not to mix apples and oranges. So if he
Oh,
is violating a court order, then that's a violation and that's contempt and that's enforcement. But it shouldn't have anything to do with the issue of her having anxiety and not having parenting time. They should be completely separate, or again, you're going to get sucked into an alienation claim.
okay. Even so, even if one of the incidences that I have documented with his violation of the court order is telling my daughter specifically, oh, the judge doesn't want me to come out of the car. The judge said I can't come out of the car and go into your mom's lobby when I drop you off. It's against the court. But yet he comes in with her in front and interrogates the door person about me and the building and purposefully creating, like, do you see what I mean? Like, he does these subtle, that's really not subtle. It's a violation of the court order.
Yeah, that is not subtle. That's a specific behavior that he is engaging in front of your daughter that is
Yes.
creating anxiety and
Yes.
discomfort. So that
Yes.
is a great example. So I would try to get like 20 to 30 examples, like very specific. Father has engaged in a pattern of behavior that has caused anxiety. If we don't have that,
Uh-huh.
then we just have a child who's anxious and then you treat the anxiety, but you don't take away a parent.
Okay. Okay, that's good. Okay. How about asking the therapist, like past therapists? Well, I guess they're kind of 50-50 also because they don't see, like, it's just so hard. Okay, but I understand what you're saying. So just document, which I have, but it's in different petitions and motions, and
Yeah, like I
it's
would change your whole strategy. Like your strategy should be
yeah.
father's specific behavior has caused anxiety and daughter not wanting to go. And then that needs to be reasonable. It needs to be like, oh, any 13-year-old wouldn't want to go under those circumstances. Dad needs to change his behavior if he wants his daughter back. Like, that's the only winning argument here, long term.
I see. I see. Okay, so itemize them. The dad's specific behavior towards the daughter.
Right, because her rejection of him has to be reasonable and justifiable, not just it's really there. She really has anxiety. Well, that's like, so what? You know?
Yeah,
Lots of kids have anxiety and then they get treated for anxiety and they still live with their parents, you know?
yeah, yeah. Another just real quick incident was when she had to get shoes for ballet dance.
Mhm.
And it was supposed to be my day, and we had planned on taking her there. And then, that this new order came in about, which was like, Thursday he would pick her up. So it fell on that day, and he wouldn't take her. She's like, I have an appointment, because I had to make an appointment. So I said, I emailed him. Anyway, he told the child, I'm not going unless your mother gives me cash.
Yeah.
And so
So-
she, again, she was like, what? Like, she's 13 now. She's not a little 5-year-old that he can just sort of pull the wool over her eyes.
Yeah. So father has engaged in a consistent pattern of manipulation and specific actions that have caused daughter extreme anxiety and discomfort at his house. And here's what they are.
Sorry, I'm just taking notes. That's good. Okay. Specific manipulation, specific, extreme anxiety. Yes. Yes. Thank you.
No problem.
I really appreciate this.
I hope it's helpful.
Yeah. It's just ongoing. It's just there's so much to untangle. It's hard to focus on what is important here in front of the
Really
judge.
hard. It's really hard to take your whole life and say, okay, so now how do I turn that into a strategy in front of a judge? You know?
Yeah. Thank you.
No problem.
One more quick question is that, so this attorney is not putting in a court order again, it seems like. It's now 4:00 here, Chicago time, and the courts are going to close at 5. So I feel like she's doing it again. Should I just leave it and let it be, or should I make a documentation to the court clerk?
I don't understand. Why do you want the other lawyer to put in an order?
I
Or a
don't know.
proposed order?
It's just for the next court date and so
Why
on and
would you
so.
want to do that?
Oh, okay.
Right?
Yeah.
Right now you have what you want. Getting the court involved in anything at all only is a risk to you.
Got it. Okay. Thank you.
Mhm.
Whew. All right. Thank you so much,
No
Billy.
problem,
I
Lisa.
appreciate it. Have a good
Alicia or Mary Alice, any other questions before we wrap up for today?
Yeah, I just have something quick. Billy, I heard you tell Alicia about the judge's orders orally. Then, so my question is, does that mean, so I would usually pick up Adriana tomorrow at 6 o'clock and return her at 8 o'clock. Does that mean that that's not the schedule that we need to follow any longer because he made those orders today?
I think the orders that he made today are real orders.
Okay, so then tomorrow I don't do that like the previous orders, and then we start next Friday, which would be my weekend with her.
And you're going to want to coordinate with Dad on that.
Okay.
Okay, here's the new orders. This is my understanding, interpretation of when they start. Do you agree?
Okay, got it. Okay. The other thing I did is in court, he was asking if I would take his weekend this weekend and then switch to him having my weekend next weekend. And because he had some kind of project he had to work on or something. So I said, I want to keep the current schedule that we have. But then afterwards, I thought, you know what I should have done was say, okay, fine, I'll take this weekend, but then we fall back into the regular schedule next weekend, meaning I would get her next weekend as well.
Right. I'm
So-
happy to take her this weekend because you have a project, but I don't want to get off, so I want to keep my weekends the same.
Right, so I sent him an OFW message proposing that, even
Okay.
though in court, because I hadn't thought about that in court on the spot.
Yep.
So I was thinking about, okay, so that's cool that I did that, just sent him a
Yep.
message, see if he's willing to go with that. Okay, cool, thank you.
Absolutely. Anything else, Alicia?
I can't think of anything else that will only take a couple minutes, other than I'm going to work on that declaration or objection, and I'll probably just post it in the group if so someone can maybe look at it.
Absolutely. All right. Thank you all. And thank you
Okay,
for joining us.
thank
And we'll
you.
see you next week. Bye.
Bye.